here's what I'm going to do, and I'm flying by the seat of my pants in part on some of this, but I'm trying to look at these folks as just real people trying to do what real people do. And here's mom trying to make sure her son gets through school. Um, and Alan, make a note of this that I did this for somebody who said they were going to be a Spartan.
Uh-oh.
Okay. I'm going to just add some language that if the defendants pay the 3541 and then Hawk says no to the 3,000, then there'll be a hearing before a writ will issue. All right. You follow me? Because I don't, as I understood it from the meeting I had, I don't know that they're going to have the money. But it sounds like what they've said to you at least leads you to believe that they are.
Yeah.
So I'm not going to let anything happen without at least a shot at something else if we have to do it. Fair enough?
Thank you. Thank you so much.
All right. You guys take care, okay?
Thank you.
So much. All right. You're welcome. Should think about a real school like Maryland. Okay. All right. Now I'm just saying, you do what you got to do, but is that it for your counsel? Thank you so very much. Okay. Arbor Woods versus Alicia Franklin.
Good afternoon, Your Honor. Rachel Dornbush, Pallets Law, P78301 on behalf of the plaintiff. Your Honor, I don't think Ms. Franklin is here, and I know that my apologies for the trouble in even asking for this, but can I speak with Your Honor privately on this matter?
On this one?
Yes, just this one.
Yeah. Can we do it at the end of your cases
Yes,
here?
absolutely.
Okay. All right. Then I'll hold that through the rest of yours. Court does call the case of Arbor Woods versus George Jones IV. When I hear it. All right. Your name?
George Jones IV.
Okay. What do you have as his balance?
With cost 2752.16.
2752.16. All right. My note here, and I don't know how real it is because is this one? This one? No, here. The green one. Okay, not that one. Okay. It's somebody else. All right. It just says client and landlord submitted all necessary documents. Client's application has been submitted to the funding source for approval. Should have an update on approval no later than 5/12. That's what the paper says.
She sent me an email saying on the 5th, Jenna Pillow over at SOS sent me an email on the 5th saying that everything's in process. They're going to update to let you guys know that that funding should be imminent.
Okay. Out to the 12th, wait for the update. If everything get paid, let's get it paid.
The 12th is
12th
is Tuesday?
No, I was sure.
Oh, okay. Can that be on Zoom? I do start a new job.
Then get to submit a Zoom request, sir.
Okay. Yeah, I start a new job on Monday.
May 15th, 2026 at 3 p.m.
Okay.
Let's see if they'll get it paid because I think after this month it all disappears. All right.
All right.
Thank you, sir. Chestnut Landing LLC versus Martez Hall. Your name?
Martez Hall.
Okay. And what is the claim in this case?
$10,000, $10,700.25.
All right. How are you gonna get this paid?
I get paid on the 25th. I'll pay it in full.
You'll pay it in full on what?
25th of this month.
25th? Okay, then here's what I'm gonna do. I'm gonna find no tribal issue after hearing. That total amount, I'm sorry, council, was 10,007
$700.25.
dollars and 25 cents. All right, I'm no tribal issue after hearing. I'm gonna issue a judgment for possession, redemption amount in that amount. I'm going to set up calling back for next basic aid. It would be the 18th. You said you could pay by
25th of this month.
25th? All right, so I'll extend out his date a week to May 25th, 2026. All right? Okay, thank you. Silo Farms versus Janelle Baker. And yeah, can you get me into Zoom on my thing so that I can go into a break?
Last one.
Last one. Your name?
Baker.
Or,
Well, thank you.
all right. How much does plaintiff have owing?
With the May charges, Your Honor, well, let me say this, Ms. Baker did make her May rental payment, but there would be a $55 late fee. With that, it's at $3,042.47. But Ms. Baker did receive approval through Hawk for $2,985.45, which is the balance less that late fee.
Got it. Okay. You follow that?
Yeah. So where's my balance at? I didn't.
It's what, $55 she needs to pay?
Yeah, it's $55 over and above what Hawk approved her for. It may be $57, Your Honor. When Hawk looked at her ledger, it had the court costs in at $190, but they're actually $192. So I think the difference between what Hawk is paying on her behalf and what's currently due is $57.
57. Okay.
All right. You think you can get that into him?
Right now, immediately. Yeah.
Okay, because the other balance, I think, is
My credit card right now.
okay. Yeah, all right. Then why don't I do this? Since that payment is coming in, you're going to get that payment in. I'm just going to adjourn it out a week to the 15th at 3 p.m. You won't need to be here if everything's paid.
Okay.
Okay. So what I'm hoping is that the check gets to them. You get the other monies in, you're at a zero, and then the case gets dismissed.
Yeah, they said it might take a couple weeks for the funds to get to Sile Farms.
When did they tell you that?
I got an email because I was following up on with Hawk earlier in the week, and they sent me an email with
The verification.
the verification, right?
What I do instead of the 15th, I'm going to go to the 22nd at 12 noon. It's no harm, but we'll let the check get there and hopefully we can just
Yeah.
okay.
Yes. Thank you. And so if those funds are dispersed and I pay that 57, I don't have to show up then.
Don't have to show up because you'll be at his.
That is the same. Thank you, Your Honor.
You're welcome. Take care. Sile Farms versus Michael Moore.
That's an issue.
First one.
He's going to tell me what to do. Yeah, that's what I told you it was. All right. How much is owing?
With costs and the May late fee, Your Honor, $2,815.85. Similarly, Your Honor, Mr. Moore did get approval from Hawk. His assistance is for $2,758.85. It's a difference of $57, the late fee and then the $2 court cost difference.
57. All right. You gonna have $57? Okay, great. All right. This for me then. I'm gonna do the same thing I just did on another 2 weeks. Yeah, I'll put it out to May 22nd, 2026 at 12 noon. Pay the 57. We'll wait for the check to get in. If everything's at 0, I don't need to see you on that day. All set. All right, sir?
Yep.
Yeah. You take care of yourself. Courthouse case of Scio Farms versus Rex Behringer.
I honestly think Joyce.
Rex Behringer or Joyce Behringer?
I think Joyce is on Zoom, Your Honor. I think she's Samsung SM. Yep, there she is.
Yep. I thought I made my way here.
All right. Hello, Miss Behringer.
Hi, how are you today?
Okay, I think. All right.
That's good to know.
Okay. What do we have on this case?
Your Honor, so Ms. Behringer made a payment via personal check on May 4th. Assuming that check clears, then her balance is going to be at, let's see, $423 plus the $55 late fee. There's still a $200, it's $423.71 plus 55, $478.51. There is a $200 payment that's still outstanding, I believe, from St. Vincent de Paul. And I believe that Ms. Behringer is still continuing to work with Housing Bureau for Seniors. Since the remaining balance, Your Honor, in essence, is really, it's a really high water bill that has been repaired, but the water bill is still going to linger because of the way the billing cycle works. And so Ms. Behringer is, though, working with Housing Bureau for Seniors to see if they can't get her additional funding to cover that water bill. If not, Your Honor, my client has worked out a payment arrangement with Ms. Behringer in the alternative. And so if for some reason it doesn't go through with additional funding, my client's prepared to enter into a conditional dismissal with Ms. Behringer with those terms.
Got it. Ms.
So I
Behringer,
don't.
you got.
Sorry, Judge.
Ms. Behringer, did you understand all of that?
Yeah, most of it.
Okay. All right.
I'm still in the dark. I haven't heard anything from anybody. And the senior housing or anybody except the young lady that was with me in court last time, Miss Madden.
That's the individual, Your Honor. Miss Madden is the one who's been communicating with Scio Farms, indicating that they're trying to get her some assistance to cover that water bill. And so, Your Honor, I don't have an objection if the court wants to adjourn this an additional week to see if we get that further assistance. Otherwise, I'll prepare a conditional dismissal for Scio Farms to present to Miss Behringer.
Okay, Ms. Behringer, here's what I'm going to do.
Okay.
I'm going to adjourn this out 1 week, May 15th, 2026 at 3 p.m. You can appear via Zoom. Okay. And you let those folks that are talking to you know that that's the date. Okay. What I want you to do, I don't want you to worry about anything. Either somebody's going to get it paid or we're going to work it out so that you can pay this off over time and you'll be okay.
I appreciate that so much, more than you know.
All right. Just don't. I know last time you were here, you were really worried about everything, and you look still worried. I know, and I'm telling you right now, Miss Behringer, you don't worry. I'm not letting anything happen to you. How about that?
God bless you. God bless you.
This entire stretch of the hearing shows just how much eviction court can depend on timing, communication, and whether financial assistance actually arrives before deadlines hit. Notice how the judge repeatedly pauses proceedings instead of instantly issuing removals. In several cases, tenants only owed tiny remaining balances after assistance programs stepped in. sometimes just $57 standing between housing stability and eviction. That's a powerful reminder of how fragile these situations can become. But the emotional center of this hearing was clearly Miss Behringer's case. You could hear the anxiety in her voice, especially while discussing the lingering water bill and uncertainty about outside support. Then the judge shifts tone completely, reassuring her directly, "I'm not letting anything happen to you." That moment changes the atmosphere in the courtroom instantly. Some viewers will see compassion and humanity from the bench. Others may wonder whether courts should stay more detached and procedural. And here's the bigger question for everyone watching. Should judges focus strictly on enforcing housing contracts, or should they actively intervene when tenants are elderly, financially vulnerable, or waiting on aid programs? Drop your thoughts in the comments, because this debate happens in courts across the country every single day.
All right. You take care. You have a great weekend.
You too, Judge. Thank you. Bye-bye.
Bye-bye. And this is what? Big.
There were a lot of filings last week. You're not.
None of that is what? What case is this on? I don't know. Can't call it if I don't know the name.
Okay.
Okay.
Oh, that wasn't helpful. I'm new.
Thank you. Spice Tree Apartments versus Musa.
Good afternoon, Your Honor. Rachel Dornbush, Pallets Law, on behalf of the plaintiff.
State your name.
Fatima Musa.
All right. What are we doing on this case?
Your Honor, I believe that Ms. Musa and Mr. Ibrahim have filed amended or new pleadings. My understanding is that what was previously filed was struck by the court as it didn't comply with the court rule. I'm not entirely convinced that what was refiled complies with the court rule. There have been some changes to it, but there are still several sections of the pleadings that still don't comply with the applicable court rules. I would argue, I suggest that these pleadings were AI generated and not appropriately revised to comply with the Michigan court rules. And so I would argue that they should be struck yet again. But I would defer to the court in that regard.
Now the hearing takes a dramatic turn. What started as routine eviction cases suddenly becomes a courtroom fight over legal procedure, alleged housing violations, and even accusations that court filings were generated using AI. The landlord's attorney is essentially arguing that the tenants submitted paperwork that doesn't comply with Michigan court rules, claiming entire sections appear copied, improperly formatted, and legally defective. That's a serious accusation because in court, formatting and procedural compliance can completely determine whether your claims are even heard. But at the same time, the tenants are raising major allegations of their own, including mold issues and claims that the property lacked a valid certificate of occupancy. The problem is that even potentially valid complaints can collapse in court if they're not filed correctly. And this is where many self-represented tenants struggle. They may feel morally right, but the courtroom still operates on strict procedural standards. The tension here becomes less about who feels wronged and more about who followed the legal process correctly. And once the judge realizes the defendants admit they're already planning to move out, the possession ruling becomes much easier for the court to grant. Still, this exchange raises a huge modern legal question. As more people use AI tools to draft legal documents, where should courts draw the line between accessibility and procedural accuracy?
What do you have to say to that?
90% of those pleadings is exhibits.
Pardon?
Exhibits. 90% of it is just documents.
Yeah, but it's got to be presented in the proper fashion.
Right.
And they're not.
The answer to non-payment of rent, correctly?
How much is owing?
Your Honor, this isn't an action for non-payment of rent. This is an action for termination of tenancy. A 30-day notice to quit was issued as defendant, Ms. Musa is a month-to-month tenant.
And we've been month to month since the beginning, or at least.
All right, but what's your defense to the termination?
We had a housing inspection on Monday, actually, because of a mold issue from February that we asked them to fix properly.
So let's assume all of that's correct. Why should you be permitted to stay in the premises?
Well, the city came to us and told us that this unit doesn't have a valid certificate of occupancy. We don't actually want to.
Okay, if it doesn't have a valid, you're going to leave then? When are you going?
Exactly. I don't plan on.
When are you going?
By the end of the month.
By when?
Month.
This is a case for possession only. They don't want you there. You say you're leaving. So.
Well, yeah, we have no problem with the possession case. It's more of a, I paid $45,000 in rent over 3 years. And first of all, the lease don't have a valid certificate and the unit has been moldy the entire time.
To get your pleadings in order on that, because that's not really properly raised before the court.
What was the issue with the answer to Naaman?
Have you gotten a lawyer on this? Because I'm not here to give legal advice.
No, we're not. We don't have a lawyer on this.
So they did not. Did you pay to sue them for a money judgment?
Say again? Did I pay them?
Yeah, you're trying to sue for a money judgment.
Did I pay the court, you're saying?
Yeah.
No, they told me there's no fee for that to file the papers.
All right.
Your Honor, if I may just add just to be specific with respect to the issues that I have with the pleadings, Your Honor, there's 2 different answers filed. One is an answer to a non-payment of rent case, which doesn't apply here. The second is an answer civil, which would apply for a general civil case. This isn't a general civil case, summary proceedings case. So there is no proper answer filed. There's a document filed called an order for change of venue, which it appears to be a request to transfer the case to the Washtenaw County Circuit Court, but that's not a venue issue. That's would be Correct. A removal request based on allegations that, based off of this, I believe his allegations are that his alleged damages exceed the jurisdictional limit of the district court. But
I don't have an affidavit on the claims.
And Your Honor, there is a document filed that's called Affidavit in Support of Petition of Change of Venue. The problem with this alleged affidavit, and in reality, Your Honor, it is a regurgitation of the alleged counterclaim, number 1. Right. But number 2, it's not an affidavit because it's not been signed in the presence of a notary. So it doesn't constitute an affidavit. And so this so-called order for change of venue doesn't apply either. With respect to the counterclaim, again, Your Honor, as was indicated at the last court date, even though some changes have been made, the bulk of this counterclaim still does not comply with the applicable court rules. And so for those reasons, I'd ask that the court, again, strike all of these documents as improper. Again, I would also, as the court indicated, this is an action for possession. Defendants are, defendant Ms. Musa and Mr. Ibrahim, who I believe is an unauthorized occupant in the unit, are in agreement with vacating. And so I don't have any authority to grant additional time beyond the 10-day time frame. So I would have to ask for a judgment requiring possession on or before May 18th. But again, I would defer to the court with respect to that.
Well, why would you say that I'm not an authorized occupant of the unit when I've been paying you guys since the beginning of the lease? I have emails with the management, or the property manager, everyone that works there, addressing me by name. I pay you. My mom has never paid anything to Spice Tree Apartments. Why would you say I'm an unauthorized occupant?
Well, it really doesn't matter whether you're an unauthorized occupant or not, quite frankly, because the pleadings and documents that are filed are not in order. They're not in compliance with the court rule. There isn't even an issue regarding venue in this case. That's not the terminology that would be used. to the extent I were to even construe it as a motion for removal, doesn't have a proper affidavit attached. It doesn't have an affidavit, as far as I'm concerned, attached to it, so it's not filed in compliance with the court rule. I'm going to order once again that the documents are stricken as they are not filed in compliance with the Michigan court rules. I am then finding also that, given the statements of the defendants, that there's no tribal issue on a termination case in this matter. I'm going to grant a judgment for possession to the plaintiff for possession. There's no redemption amount. A writ would issue in 10 days.
No.
Pardon?
2 weeks.
Pardon?
2 weeks on the writ.
18th.
And it's
You'll have to deal with the landlord if you want additional time, but it's 18.
and I have no problem giving the property back. If they're not going to fix it, I don't want to live in a moldy unit. Is there no issue, even if with all the documents being struck, is there no issue with them renting me a property that is not compliant with the city?
There may be an issue,
Right.
but you have to file the proper paper. I'm not going to make your claim here. You have to do it properly.
Okay.
So if you don't know how to do it, get a lawyer.
Give us time to do that. We got this summer.
Sir, you filed the additional pleadings. I had to strike them.
Okay.
Then you redid it. I had to strike them again. I'm not going to waste my time waiting for you to get it right.
I'm asking for time.
If you wish this court to do something else, get a lawyer. They can file a motion with this court to do something else. But at this point, I am not. The judgment that I've issued just now will stand. Thank you.
And Your Honor, I would just also point out that to the extent that they feel they have a claim against my client, it does not have to be brought in conjunction with this case. I would disagree that they have a claim, but that doesn't change the possession issue. So
That's right.
So
Yes, ma'am.
can I ask a question? Can I move my name? Because this is
She doesn't live here.
this is his problem. I live somewhere else.
You live someplace else.
Yeah.
I know, and that's what we were told. The problem is you're still on the lease. I can't remove your name.
By the end of this hearing, the courtroom delivered a mix of compassion, procedural enforcement, and hard legal reality. Several tenants avoided immediate eviction because emergency assistance programs appeared ready to cover their balances, while others were given extra time to stabilize their situations. But the most controversial case involved a dispute over allegedly defective legal filings and unsafe housing conditions, where the judge ultimately ruled that regardless of the tenant's complaints, the court could not ignore improper procedure. That's one of the harshest truths about the legal system. Even if someone believes they've been treated unfairly, courts still require claims to be presented in the correct legal format before they can act on them. In the end, possession judgments moved forward, deadlines were set, and the judge made it clear that future action would require proper legal filings and possibly professional representation. And honestly, this hearing had everything: emotional testimony, financial desperation, procedural chaos, and a judge trying to balance empathy with the limits of the law. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Thank you. Spice Tree versus Andrew Fuller.